Hi, my name is Zach Parry. I'm an attorney with Lawyers Plus. Today I'm going to be talking to you a little bit about the legal theory of negligence. Now, negligence is probably the basis of more civil claims than any other. Negligence encompasses a wide variety of behavior for which you can hold someone else accountable. Now, negligence, by its definition, is an unintentional tort. Now, a tort is similar to a crime, but on the civil side. It's like a civil wrong. There are intentional torts, and then there's negligence. Negligence meaning you can be held accountable for your behavior, even if the behavior wasn't on purpose. Because the theory under negligence is that we all owe everyone else a duty to act reasonably, and if we are not acting reasonably, we can be held accountable for the losses that our failure to act reasonably causes in others. So, there are certain elements that must be proven by a plaintiff in order to recover for negligence. In Nevada, those elements are there must be a duty. So the defendant must owe the plaintiff some sort of duty. There must be a breach of that duty. The breach of duty has to be the actual and legal cause of the plaintiff's damages. So we'll talk briefly about each of those four things. The first is the duty. As I mentioned already, everyone has a duty to act reasonably towards everyone else. That's kind of a catch-all. But there are also some very specific duties. Sometimes the relationship is the basis of a duty. For example, a teacher owes a heightened duty to their students, as does a hotel to their guests or an airline to their passengers. If there is a relationship like this, there is a heightened duty standard, and it is easier to show that this duty has been breached. Duty can also arise from a statute. So if there is a statute that requires certain behavior, for example, a speed limit, if the speed limit is 65 and someone is going 80 in a 65 and causes an accident because they were going too fast, that's what we call negligence per se, and that is to say the duty and breach elements of negligence have been met by virtue of the fact that a statute was violated, a statute whose purpose is to prevent that kind of harm, and the statute is designed to protect the class of persons that were harmed. So speeding statutes are designed to protect people from accidents. So if you were harmed by someone who was speeding, then you don't actually have to prove duty and breach to recover damages for negligence. You just have to prove that they violated the speeding statute and that statute was designed to protect you from the type of harm you suffered. So that's the duty element of negligence. Then there's breach. You have to show that this duty was breached. You have to show that they didn't fulfill their duty. As we discussed in the speeding example, you have to show not that they breached their duty, but just that they violated the statute. If it is just the common law duty to act reasonably to others, you have to show that whatever they did was unreasonable, that a reasonable person would not have engaged in that type of behavior, and therefore they breached the duty. And because there is so much room, it's a gray area, the breach of the duty. So there's a lot of room for argument, and that's where attorneys make their money, and earn their keep, so to speak, is in convincing a court that either a duty was breached or that it wasn't breached if they represent the defendant. So that's duty and breach. The next element is causation. There's two types of causation. There's actual cause and there is the proximate or legal cause. The actual cause is fairly easy to prove. It just answers the question, would I have been injured but for this behavior? So if you can say, I would not have been injured in this car accident if he had not been following so closely, that's an actual cause. The proximate cause is a little bit more difficult. The proximate cause or legal cause asks us how foreseeable the injury was from the alleged breach of a duty. So there has to be some sort of relationship. Well, if you're following too closely, it is pretty foreseeable that you could rear end someone and that they could suffer injuries as a result. So you'd have a pretty good argument for proximate causation if someone were following you too closely. And really the question we're trying to answer in determining whether the proximate cause prong of negligence has been met is, does it seem fair to hold someone accountable for this injury based on this failure to act reasonably? That's not a legal paraphrasing, but that's more or less the question we're asking when we're looking at proximate cause. And it's based on how foreseeable is the injury from the action. Then the last element is damages. Now damages, that's just a legal term of art meaning loss. So there has to be some loss. You must have lost something. You could have suffered property damage if your car was hit by someone else's car. It could be injuries. Bodily injury is certainly loss. If you suffer from emotional injury, anxiety, those are losses. There are all sorts of losses. Pain and suffering, loss of consortium, loss of enjoyment of life, lost wages, lost earning capacity, loss of household services. Anything that you lost when you compare what would have happened had the negligence not occurred with what actually happened, subtract those two, those are your damages. And there has to be some element of damages for you to be able to prove negligence. Now, as I said, most civil cases, or at least more than any other, are based, at least in part, on negligence. I've been talking more in the context of car accidents, but it could be anywhere. It could happen in a grocery store. For example, the negligence in Nevada, when you're visiting someone else's property, is a special kind of negligence called premises liability. And in Nevada, the way that we analyze these four elements in a premises liability case is to look at whether there was a dangerous condition present on the property that the landowner either caused, knew about, or through the use of reasonable care should have known about, but failed to remedy, and that this failure to remedy this dangerous condition caused you your damages. So that's how we look at a negligence, the negligence elements in a premises liability case. So if you have questions about negligence, give us a call. We know what we're doing. We'll be able to answer your questions and perhaps help you in the legal realm.
Lawyers Plus, we earn your trust.
Do you need to speak with a lawyer? If so, call one you'll actually like.